Oh dear. Very rock and roll.
Right, so I've just pressed the record button, so we're ready to go on that. Just wait for 4 o'clock to tick over.
Should we put our mics on then? Off.
Yeah, well, you're all ready to go there. There we are. That's 4 o'clock. So I'll just give it a couple of seconds, and then we'll all ready. Good. Okay. Let's rock and roll then. Good. You see participants are arriving. Well, good afternoon, everybody. Welcome to the Thrings Business Health Matters, the final webinar of 2020. It's good to have you all on board. I'll just do a little bit of an introduction while our participants are gradually joining the meeting. This meeting or this webinar is being recorded, so it will be available on catch up if there are any points that you have missed during the presentations, or indeed if you feel it was appropriate to share it with any of your colleagues or any other business associates who might well find it useful. So but please do that. My name is Chris Elias. I'm a relationship director with Thrings. I'm not one of the lawyers in the firm. I come from a banking background, and there's some interesting elements in terms of banking which will come out during the session this afternoon. So I'm looking forward to that. The Business Health Matters series is a series of webinars that we've been running throughout 2020, which is designed to give our clients an insight into some of the major issues which have faced them during the pandemic. It's been very well received, and interestingly, some of the points that we're now picking up at the latter part of the year are sort of add-ons and developments of issues that we raised early on in sort of June, July time. So it's going to be interesting to see how those pan out. We are due to have a break over New Year and come back in February with a session on issues facing family businesses and medium-sized businesses. However, dependent on what happens in terms of Brexit, it might well be that we slot something else in January to pick up in terms of any issues which come out of the negotiations, which, as we all know, are very much live and ongoing at this very moment. So today's topic of discussion is business protection, and I'm delighted to say we have 3 panel members here today. As you can see, I'm the thorn between all the roses. First up, we're going to have Melissa George. Thumbs up from you, Melissa. Wave. Thank you. Well, and Mel's a partner in our restructuring and insolvency team, and has extensive experience in dealing with a whole range of insolvency issues, particularly in terms of property for a range of stakeholders. And I have a funny feeling that Mel is going to be very, very busy over the next couple of months, sadly, and it'll be interesting to hear what Mel has got to say. Secondly, we have Caroline Watson. So wave from you, Caroline, please. There we go. Thank you, Caroline. So Caroline's key focus is on commercial dispute resolution, and she's specializes in high court litigation and arbitration clauses, often including some element of cross-border transactions. So that's another interesting string to the bow. And finally, we have Megan Jefferies. And Megan, thank you. This is Megan's first webinar, so glad to have you on board, Megan. So Megan specializes in intellectual property disputes, including copyright and trademark infringements and company names disputes. She also has extensive experience in dealing with commercial contract disputes as well. So it's going to be interesting to hear what Megan has to say this afternoon as well. This will be an interactive webinar. We will endeavour to run a poll at the end of each section, just to get a flavour of what the thinking is in terms of the members who are joining the webinar this afternoon. And you'll also see that there's a Q&A button on your screen as well. So if you have got a question which you feel you'd like to answer, please raise a question, and we'll endeavour to cover those off specifically at the end of the webinar. Or alternatively, if they're a little bit more complex or personal, we will follow them up outside the webinar process. So there we are. That's my introductions over and done with, and I'm pleased to welcome Mel into the hot seat. So Mel, thanks. You've taken your microphone off mute, so welcome. Good. Now, Mel, you're going to sort of cover off some of the interesting elements of the Finance Act 2020. One of the key issues is Crown preference, which was restored with effect from the 1st of December. So, good starting point, Mel. What is Crown preference?
Right. Well, it's essentially about the order in which creditors get paid in an administration or a liquidation. Essentially, there's a prescribed order. The creditors are paid under their fixed charge first. So, for instance, those with a mortgage. Then the expenses of the process are paid. Then preferential creditors. Until now, that's been limited to employee pay, arrears of holiday pay, up to certain caps. Then the lender is paid under its floating charge, subject to a small carve out that is actually paid to unsecured creditors, known as the prescribed part. HMRC have been given preferential status for VAT, PAYE, employee national insurance contributions, and construction industry scheme deductions. So from the 1st of December, the tax liabilities are paid to HMRC before sums are paid to lenders under their floating charge, and sums are paid to the other unsecured creditors. This doesn't extend to corporation tax. It's limited to VAT and employee-related tax, but there is no cap on the amount that can be claimed or the period in which they can look back. So it could be quite significant.
So in practical terms, Mel, what does that mean for businesses?
In a way, it may help cash flow, with perhaps HMRC being more inclined to offer some breathing space because there's less risk to HMRC should the company fail. It does remain to be seen what their attitude will be and whether it will change their attitude towards winding up companies. There are, as you alluded to earlier, some real implications for borrowing. The lender's security is essentially going to be worth less than it was. So that means that lenders are likely to scrutinise the headroom in their facilities. It may mean that they're not prepared to lend as much or to roll over existing debt where there's not enough headroom. So directors really need to be alert to when the facilities expire and plan for their exit from that, particularly perhaps if they're in one of the areas that's been affected by the pandemic, either short-term or long-term, or they're in a time to pay arrangement. It could have a knock-on effect with the cost of lending, with the increased risk, meaning it may be more expensive. And I also expect banks to be monitoring covenant compliance a lot more, and they may actually broaden their step-in rights so that they can act earlier if they feel they are at risk. Mm-hmm. They will probably start looking at other security, so they may look to see if they can take assignments of other assets. They may look at de-risking group structures. For directors' perspective, there's likely to be a greater requirement for personal guarantees. There may be a greater call on guarantees because there could well be an increased shortfall. So they may also look to see, well, do the directors actually have assets? And they may look to take security for those guarantees as well. As to other impacts, CVAs are a key part of the restructuring toolkit, and this may affect the viability of CVAs when we're looking to restructure businesses next year. Preferential creditors, unlike unsecured creditors, can't be compromised within that company voluntary arrangement. So if HMRC wants to be paid in full for this preferential debt, it must be. That will mean that unsecured creditors will get less from the voluntary arrangement, and it may mean that the voluntary arrangement isn't viable. Finally, if you're a creditor of a company that's failed, your dividend return is going to be less because HMRC will be paid in full before you even get a look in. And sadly, a number of companies have taken the opportunity of the VAT deferral, so there are greater liabilities to HMRC at present.
That's just waiting out there. Yeah. Okay. Thanks for that. So another issue: wrongful trading. There's been some changes to the wrongful trading rules, I understand, as well. So what's happened there?
Yes. So, Chris, this is that risk of directors facing personal liability to contribute to the assets of the company where the company's found to have had no realistic prospect of avoiding liquidation or administration. And importantly, they failed to take every step to minimise the loss to creditors. You may recall suspension legislation was introduced in April, meaning that directors were not deemed to be responsible for the worsening financial position for the period 1st March to 30th September this year. So they couldn't be asked to contribute to any further losses.
Mm-hmm.
New regulations were introduced, reintroduced that protection with effect from the 26th of November, and that protection runs through to the 30th of April next year. Oddly, there's an 8-week window in the middle where there is a risk of liability. So from September to November. Was it deliberate or not? We don't know, but overall, this will give a level of comfort to directors. But, I bang this drum a lot. Directors are custodians of companies. They owe a number of duties to the company. And when the company is insolvent, whether cash flow or balance sheet, they owe duties to creditors. So directors should be aware of what those duties are and be mindful of them.
Yeah, very, very important, certainly. I think just before we sort of move on to some practical tips, then, Mal, I'm just going to run the first poll of the day. So if you just like to have a look at these poll questions and perhaps answer them as Mel is answering her next section, and then we'll reconvene and just have a look at them. So just launching the polling now for everybody, if you'd just like to have a look at those. So I guess we'll move on to then some practical tips, really. So what are your top tips, Mel, for directors as part of their decision-making process in the climate that we find ourselves now?
Okay. There is no hard and fast rule because cases are always assessed on their facts. But if a business fails, ultimately directors will need to explain what happened. They may have to justify why they continue to trade despite accruing liabilities. And clearly there's going to be an element of hope value in this, that businesses will return to a level of normality next year. But ultimately, keeping records and justifying your decisions are key. Insolvency practitioners look at your business records to assess whether you acted reasonably as directors and whether claims should be made against you as directors. So with that in mind, as a start, I'd really think about taking the following precautions. Hold directors' meetings. They probably need to be more frequent right now, given the challenges. Be on top of your finances, know the financial position of the company and your exit route from the constraints you're currently facing as best you can. For example, how will you pay that deferred rent or tax, for instance? Always consider the impact of your decisions on your creditors and if you need to engage with them. When dealing with creditors, remember that if the business is insolvent, all creditors must be treated the same. You shouldn't pay some over others without very good commercial reason, and you should really take care if you're being asked to grant security for old debt. These are the sort of things that can be looked at. I say evidence is key, so document your decision-making process. Even if you are a single director or member business, it's easier to face down criticism if you can show proper consideration and commercial justification was taken at the time. Finally, be proactive, take advice if you need it. Decisions around continuing to trade, ceasing to trade, or indeed restructuring options are never easy. But professionals across practices may be able to assist you with your options. And And if you're struggling, it may actually lead to the survival of the business and better return for your creditors and your partners.
Oh, brilliant stuff. Okay, thanks, Mel. So I'm just going to, we've had a couple of people who have responded in terms of the poll, and I'll share those results there. I think the interesting thing is if we look at least, I think, really in terms of those who have regular board meetings and keeping records of decision making, I think two-thirds of those who've responded do, which I think is a good sign. And really, I think our recommendation to everybody is to make sure that you follow that process. You know, keep those records. So thanks very much, Mel. Appreciate that. And so, Caroline, I suppose we move on to your section now, and I think this is going to be quite interesting, really, because I think it certainly picks up one of the topics that we discussed earlier, and that in the year, and that was certainly in terms of business interruption insurance. In July, there'd been a lot of press talk about it, but no real clarity, as with a lot of things throughout the COVID process, really. So what's happened since July? You know, what have the developments been?
Thanks, Chris. Yeah, I think the good news is since July, things have moved on a little, but we're not quite at the end point for business interruption policy holders at the moment. Back in July, the main issues which were arising for those who held business interruption insurance were that they were finding that their policies pretty much limited them to covering losses for property damage, for example, as a result of a fire or flood, and that these types of policies weren't really designed to cover pandemic risk. So the vast majority of policies weren't designed for a COVID type situation. The good news at that point in time was that if you had purchased a policy extension, which, for example, covered an inability to access your property because of a government or local authority restriction, or another example would have been the occurrence of a notifiable disease within your vicinity of your premises, there was more likelihood that you might have cover for COVID-related losses. But the problem that was arising kind of in the industry at large, really, was that different insurers were interpreting those policies differently and inconsistently, which was leading to more confusion and uncertainty for policyholders than had been caused by the pandemic, and just kind of exacerbated that. As a result, the Financial Conduct Authority, which is one of the insurance industry regulators, stepped into the shoes of policyholders and started court proceedings, or a test case, against 8 insurers, which was effectively asking the High Court to determine how a representative sample of business interruption clauses should be interpreted. The point of the proceedings was to try and get some clarity and fairness for policyholders, and to ensure that there was kind of a baseline standard being applied across the industry. So since July, those proceedings in the High Court have been heard, and the judgment was issued in the middle of September. That judgment, whilst giving some clarity, has been appealed, as everyone expected it would be, interestingly, both by insurers and by the FCA, and permission was granted for that appeal to proceed straight to the Supreme Court, leapfrogging the Court of Appeal. Again, everything's been dealt with very quickly, and that Supreme Court hearing took place a few weeks ago in the middle of November, and we're currently awaiting the results of that decision.
So in terms of the High Court decision, then, a good lawyer, don't sit on the fence. Yes or yes or no? Would it be helpful for policyholders?
I'm going to have to sit on the fence a little bit, but broadly, yes, it has been helpful for policyholders. The High Court looked at kind of categorised 3 different types of policies. The first one and the most helpful area for policyholders was if you have a policy which contains what's being referred to as disease wording, so the occurrence of a notifiable disease within the vicinity of your premises. We'd expect, and the High Court would expect, most policies with that type of wording to pay out based on the government's national response to COVID. Insurers have tried to argue that it depended on what had happened locally, and those arguments were rejected by the High Court. So if you've got a disease wording in your policy, more likely than not, you should be covered for COVID losses. If the second type of policy wording the High Court looked at was for policies which contain prevention of access clauses. This meant that you couldn't access your premises as a result of a government or other authority action. Less clear-cut on the High Court decision here, but still broadly helpful for policyholders. Policies may pay out, but it depends on the specific wording, and also it depends on how your particular business and your industry was impacted by the government response to the pandemic. The third type of clause the government looked at was kind of a hybrid of the other two, so restricted access to a premises because of a notifiable disease in the area. And again, here the court took a hybrid response to that, and it ruled that the disease part of the clause should be widely construed, but the restriction part of the clause would require more than the impairment of normal use of a premises. So with these types of clauses, we need to look at the wording in a bit more detail, but probably you are likely to be covered for COVID losses. There was another element that the court looked at, which was the application of what's called trends clauses. These relate to the calculation of loss of profit if you have got cover, or calculation of loss of profit and the expenses that you've incurred as a result of an insured event. They allow insurers to take account of ordinary trends that would affect your business regardless of the insured loss. And now the court rejected the insurer's approach, which had argued that the pandemic should be kind of factored into the trends that occur to your business, and this would have negated the value of a lot of policies. So even if cover had been provided and you got over that hurdle, your payout would be low or minimal, because the pandemic could have had an impact on ordinary business trends. The court, in reaching that decision, gave very specific guidance on how trends clauses should apply for different types of policies, and again, that's really helpful for policyholders in ensuring that if they've got cover, it's kind of viable cover that has some level of quantum attached to it. So broadly good news, Chris, and certainly a lot more helpful than that could have been the case.
So, but presumably, are claims being held back now? Because I assume people will wait for the Supreme Court decision, and sort of. So when is that due, and what's likely to change?
Yeah,
if anything?
So some claims are being held back, and certainly, for example, one of the main insurers that's involved in this this case is Hiscox, and they've said that they're not paying out on claims until the Supreme Court decision is released. The Supreme Court dealt with an appeal by both the FCA and insurers. Very broadly speaking, the FCA was asking the Supreme Court to provide clarity on a few areas that it didn't think the High Court had dealt with in sufficient detail. Probably the most interesting of those for our purposes is where there had been a partial closure of a business. So, for example, the eating area of a cafe had been shut, but a takeaway business could continue. Was that enough to trigger the operation of a prevention of access clause? And I think that's going to be, if the Supreme Court decides in favour of the FCA on that, that will be hugely helpful to a good number of businesses and being able to claim on their policies. Insurers also appealed the High Court decision, as we'd probably expect, given that it broadly went against them, their areas of appeal are much more nuanced and detailed, but can broadly be summarised as relating to causation of loss, and whether the COVID pandemic and the government's response to it caused loss. One important point of the High Court decision was that the insurers should treat COVID disease and the government's response as one cause. Insurance have argued that the disease itself and the government response to the disease should be separated as two separate causes, and that's an important element of what the Supreme Court's been asked to decide. The appeal hearing, as I said, took place at the end of November. The Supreme Court said that it will get its decision out as quickly as it can, and certainly the whole process of this claim has been vastly fast-tracked in comparison to a usual claim, but it hasn't committed to having that out before Christmas. I would expect probably we'd see it in the second half of January, but they're beavering away at the Supreme Court to get it to businesses as soon as possible, because they realise that clarity is needed urgently.
Well, and it is, isn't it, really? As with all the uncertainty at the minute, it's, a decision would be sort of very, very much welcomed, I think, by everybody. So yeah. Good. Okay. So just out of interest, really, I'm just going to launch another poll just to see whether anybody's made any claims so far. So that's going to launch a brief poll there, and I suppose just to come on to finally wrap up then, Caroline, what does all this mean for policyholders at the minute then?
Yeah, I think at the moment our advice is actually pretty similar to what it was in July, because there's still a lack of finality, but that until the Supreme Court decision is released. But the good news is that finality will be coming, I'm sure, by the end of January. So there will be some clarity. If you're kind of in a holding pattern with your insurers, we'll have that finality by certainly the end of January. I think practical things that you can do if you are considering making a claim on your insurance, or have made a claim but are in that holding pattern, or if your insurance has rejected your claims, is to keep a dialogue going with your insurer and or your insurance intermediary. If your insurer has refused to pay out but you disagree on your understanding of what your policy should be covered, take advice on the specific terms of your policy and whether or not you should be taking action to reject that decision. The important point about all of this in the FCA test case is that it doesn't prevent insurers taking their own action against their insurers. So if your policy is a valuable one to you, consider it issuing making a reference to the financial ombudsman, or even whether court claims or arbitration claims are appropriate, and certainly take advice on those. Another point, and again, advice that we gave in July, is if you feel that your broker hasn't pressed your insurer enough, or hasn't even put your claim to your insurers, insist on that claim being put to insurers, and don't take no for an answer from your broker. The other point to bear in mind, depending on the outcome of the Supreme Court decision, if you are successful in getting insurers to agree cover and there is payment or payment is made as a result of the Supreme Court decision, that payment will have been delayed quite substantially on when it should have been made, and you may have additional claims for damages against your insurer. And certainly, for example, the Action Group in relation to Hiscox insurance are very directly looking at whether they have additional damages claims for late payments, and whether that's something that Hiscox could be on the hook for.
I think certainly interested in there in terms of if there's a broker involved, and certainly pressurized. So that's so I think that's important for everybody to take.
And I think that's the overall message, Chris. Keep pressure on your
keep
insurers.
Banging on the door. Yeah, brilliant. Okay.
So just where you need it.
Yeah, so just sharing our poll results now. Interestingly, we've got at least one person on the call who's made a successful claim on the.
That's really good to hear.
Which is great news. So it's clearly worked for somebody.
Well
so that's excellent. But nothing else planned from anybody else in terms of COVID related issues. So, but at least somebody's been successful. So that's And
I'd imagine that success is in relation to the lockdown earlier in the year. There's always the option of making another claim for the recent lockdown as well. So that's something that shouldn't be forgotten.
2 claims. Good advice as well. Thanks, Caroline. Brilliant. Thank you very much for that. So Megan, call you up into the mastermind chair now. You're in the hot seat. So welcome. So we're going to have a look at intellectual property and trademarks. So, and I think a lot of this is perhaps more Brexit related as opposed to the pandemic related, but it's interesting stuff nevertheless. So, I guess if a business has got a European trademark or a portfolio of European trademarks registered, will those trademarks continue to give them protection from infringement in the UK after the 31st of December?
Well, the short answer is no. An EU mark won't give you protection in the UK after the end of the transitional period. But there is good news in that the government has made very clear that what it's going to do is clone those EU marks, so that what you'll end up with is an identical EU mark, parent mark essentially, with a cloned UK mark, which also retains the same filing date as the original EU mark on the register and covers the same goods and services. It's automatic, the government will do it, you don't need to make any application, and that also means you don't need to pay any fee. So good news there.
Yeah.
If the situation could arise whereby a business ends up with 2 marks that are virtually identical on the register, because for example, if a business has started out in the UK and it's initially just made an application for a UK trademark, maybe they've expanded and then further down the line they've got an EU trademark, they've applied for and obtained an EU trademark, then that EU trademark will be cloned, so they could end up with these 2 virtually identical UK trademarks.
Yeah.
EU and UK trademarks last for 10 years, after which time they have to be renewed, but there's no obligation to renew. So in that situation, the business owner could just make the decision not to renew one of those marks. They don't have to maintain both of them on there, so they don't need that double payment and double protection.
Okay. So what about the situation then when an application has been made before the 31st of December, but it's not been granted and registered before the end of the transition period? There's a bit of a limbo there, isn't it? What's likely to happen there?
It is a bit, and that's, the government has said that they won't be cloning those applications. So if your application hasn't yet gone through and you don't have your registration certificate before the end of the transitional period, it won't automatically be cloned into the UK. You have to actively make an application. So you have to make a separate application to the UK IPO and you have to pay the fee as you would normally. But there will be a grace period of 9 months. So if you make your application to the UK IPO by September 2021, then that UK application will have the same filing date as the EU mark. So you'll gain in that respect, but you do have to actively do it. It won't happen automatically as it will with the already existing marks.
Okay. So is there anything then that a UK business needs to be aware of at the end of the transition period in terms of maintaining UK trademark protection?
Yeah, one important thing is that EU and UK trademarks are both vulnerable to challenge if they're not used in respect to the goods that they're registered for within 5 years. So at the moment, while we're part of the EU or while we're in the transitional period, use of a mark in the UK will constitute use within the EU. But after the end of the transitional period, using a mark in the UK, won't constitute use in the EU. So it could make UK business owners with EU marks, those marks could be vulnerable to challenge from them not using them. So in terms of what I would advise those businesses to do, it's make sure you do use your mark in the EU, if of course you want to continue to maintain your protection there. So for example, have a website that's directed at the EU, that's offering prices in euros, keep records of sales that you make in the EU, of orders that come in from the EU, keep your paperwork basically, just so that if someone does come along and try to challenge the validity of your mark, saying you haven't used it in the EU, you've got that evidence there ready to go to show that you have. So
I guess could that just jump in? Could that be just focused on one EU country, say southern, area, Southern Ireland? If you just wanted to really limit it, that's all you need to do.
Absolutely, yeah, just one country in the EU.
Okay, well that's quite important and perhaps a quick get around. Okay, then. So what about patents and other IP rights, such as sort of copyright and design rights? How will our leaving the EU sort of impact on those rights?
Okay, so patents aren't governed by EU law, so there'll be very little, if any, change to that after we leave, after the end of the transitional period. Design rights, it'll be pretty much as I've just outlined in relation to trademarks. So the same thing will happen, you'll get an automatically cloned design right on the UK register. Copyright is a bit different. Copyright in the EU and the UK isn't something that you have to apply to register, it's just something which automatically occurs. So that means you don't have the same administrative headache around leaving the EU in relation to copyright, because there's no registers to update or anything like that. What may happen is that as the UK courts and the EU courts interpret copyright law and make decisions on copyright matters that are before them down the line, we may find that there's a divergence between the laws in the two jurisdictions when different decisions are being made by different courts, because they're not all having to apply the same laws any longer.
Okay. Right, I'm just going to, there's a very brief poll in terms of Meg section, which I'm just going to launch now, which is just very much of interest for ourselves, really, in terms of who has got trademarks, etc. So I'll just launch that now. And I suppose coming into sort of the final points of your presentation, Meg, really, in terms of trade and IP rights. So if you've got a situation where you've got a UK business selling the goods of a EU business, the UK business may have sold the same goods in the UK and in the European Economic Area before the 31st of December. Is it still able to export to the European Economic Area after the end of the transition period and get that protection still?
It's still able to, but there are things that need to be taken into consideration, just more things to think about. I mean, I'm just talking about the IP here. There's also tax implications that the businesses will be need to aware of. But in terms of the IP implications, whilst the UK was part of the EEA, if goods were put on the market in the UK with the consent of the IP holder, the IPR in those goods would be exhausted, by which I mean the IP holder, the IP rights holder, would no longer be able to exercise its rights to prevent the sale. As at today's date, there's no UK-EU trade deal, and the governmental guidance on the area remains unclear. However, my current understanding is that unless we come to some agreement with the EU to the contrary, putting the goods on the market in the UK by or with the consent of the IPR holder won't exhaust the rights in the EEA. So what that means is that even if the goods in question have already been sold here in the UK, where the business then exports those IPR protected goods out of the UK to the EEA, it will need the IPR holder's consent to do that. So anyone exporting from the UK to the EU will be well advised to get the IPR holder's consent before doing so, to avoid getting themselves in hot water.
Another potential minefield for people to look out for there again, isn't it, really? Oh, gosh. So that consent then, does that need to be explicit?
No, it can be implied or it can be by inference. So it doesn't have to be express, it can be implicit. But I would always advise, unless there's a good reason not to try and get express consent, because that's obviously going to be the one that you're least likely to then face any challenge from the IPR holder if they've already expressly consented to you doing that export.
Yeah, exactly. So I think that there's probably a common theme, isn't there? Really, in what everybody has said. Get things written down and get the consent. Make the notes of your board meetings. If you've got the evidence, you protect yourself as much as possible, don't you? And I think that sort of covers all areas that we've discussed this afternoon. So very, very important. In terms of our brief poll on that section, a couple of people have got EU trademarks, which is or UK trademarks, which is interesting, and impact anticipated as well. So it's going to be interesting for everybody there in terms of how these sorts of things pan out over the coming weeks and months. People will be effective as our poll has showed. So thanks for that. All right, if I stop those there. Now, we've come to the end of the sort of the formal part of our procedures. As I said earlier, we do have a Q&A facility. If anybody wants to has got any questions that they'd like to raise to be answered live or to be followed at a later date. We have got a couple of questions that have come through, and just having a look at those. And this is quite one for you, I think, Mel, in terms of. We talked about fixed assets and what preferential claims will cover. What are the classes of fixed assets which would be, the classes of assets which would be covered by a fixed charge? Oh, Mel, you're on mute. There we are. That's better.
Better. Good question. I was saying.
Quite answer.
It's a secret. No. Fixed assets are generally the larger assets that you can identify. So it's your building, your plant and machinery, and your goodwill. Floating charge assets are things that are generally your current assets in your balance sheet. So that's going to be your stock, your cash at bank, your book debts. Banks, lenders do those assets, some of those current assets, those floating charge assets can possibly be caught by a fixed charge if the lender has control over them. So sometimes you'll see lenders wanting book debts being paid into, say, separate designated accounts, which you then don't use routinely in your business, or they may take assignments, legal assignments of your book debts. Things like stock will generally sit under the floating charge anyway, but I can see the banks and lenders looking to try and gain a level of control over the floating charge assets, or some of them, to elevate them to a fixed charge.
Certainly, with my banking hat on, I would certainly say if there's anybody out there that's got working capital lines which use either factoring or invoice discounting, obviously those are definite fixed charged over book debts. Some people might have an overdraft facility where they have a monitoring formula or a management formula which links their overdraft utilization against the level of their book debts as well, and needs a certain percentage of cover. It could quite be that the lenders out there take a more stringent view of those type of arrangements and could start winding in overdraft facilities because they don't have the security of those fixed charge over those sorts of debts, because they vary so frequently. So certainly bear that in mind if you're out there and you've got an overdraft facility which is linked to a lending formula over your debtor book. Very, very important. So thanks for that. Another question which has come in, Mel, again, this is for you as well. So we've got wrongful trading due to those changes due to expire on the 30th of April. Now the world's not going to be a different place on the 30th of April, is it? It's certainly, in terms of my mind as well, really. It's the outlook is not going to be an awful lot rosier. There are a lot of businesses that are still going to be struggling and are going to be having to make firefighting decisions to keep themselves going. Is any scope for extension, do you think, in these wrongful trading laws?
It's difficult to call, really. I don't think there would be much of an appetite to extend the protection much further. There's a couple of issues, really. One is there was a question mark whether it was going to be extended this time round, because actually claims for wrongful trading are often brought in tandem with other claims against directors. For example, the allegations that the directors didn't consider the interests of creditors. Those claims will often run in tandem. The claim for wrongful trading exposes the director to liability to contribute to the assets to the amount by which it's considered they increased the deficit to creditors during that extended period of trade. The claim against the claim that the directors failed to have proper regard to creditors is a claim for damages. The liability is then assessed again against the loss that accrued in that time. So there may not be good cause for extending that protection alone. There is no current protection afforded to directors for this other claim for breach of Companies Act duty to creditors. And quite frankly, Chris, at that time, we're at April, potentially businesses owe a year's worth of rent. They're having to come to a decision as to how they're going to start to possibly repay the interest that's due on the C-bills. They're having to look to how they're going to pay the VAT deferral.
VAT deferral.
So actually at that time, directors really do need to be taking critical decisions, saying, look, can I carry on either at all, or do I need to look at the model and the debts and restructure?
Yeah.
And without a catalyst, an incentive to take a decision, the decision may not be taken, and then the problem could just be a lot worse for a number of creditors months down the line.
Brilliant. Okay. Well, I think very sobering words to finish our last session of 2020 there. So I'm sure on behalf of everybody who's joined the webinar today, big thank you to Mel, Caroline, and Meg. Thank you for your input. It's been fantastic, very enlightening yet again. As I say, there will be a recording of this webinar going out for people to review and share. So on behalf of Things, thank you for joining us throughout 2020. We look forward to seeing you again in 2021, and fingers crossed it's going to be a much nicer and more successful year for all of us. Have a happy Christmas, everybody. Have a good season and a happy New Year. Bye, everyone.